How did you already know that he was gonna be your client on
I already seen him.
the April 1 calendar?
I think he showed up somewhere.
Oh, okay.
Because he was doing it as a bench warrant. He was already my client. So when I went, when I saw that on the, what Lee sends out of the bench warrant thing.
Oh, okay, got it.
One last thing, I think we're good. Good morning, Ms. Rivers. Hope you're feeling a little better. Can you hear us?
Good morning. Yes, I can.
Great. Okay. Well, let's get started. We have a mixed calendar here. First few positions, I think, are playing arraignment. Position 1 is Douglas Dunn.
This should be transferred back to non-complex. Good morning.
Good morning. Because?
This was, so I talked to Ms. Nelson about it when this calendar came out. I think it was sent here inadvertently.
Great.
I don't think it was a true repeat offender.
Okay. Well, let me take a quick look. So is Mr. Dunn in custody?
No. Yeah, I think he got out.
No. Okay. Good, since it was a March 2023 case.
Judge, it's on my list to do. I don't believe I've transferred it yet.
Okay. I don't even see an order transferring it to us.
Right, that's, Ms. Nelson and I were like.
Oh, in fact, it says in the docket, it's non-complex.
Right, so.
Bizarre. Okay,
Yes.
great. So that goes, that basically stays where it is.
Yes.
Okay. NC2. All right. Well, I like that outcome. Theo Francois.
Oh, yes, Your Honor. I need to talk to him because he was just brought over.
Okay. And people are up?
Yeah,
Okay.
325.
Right, I guess we have a couple inmates from ACDC who are not here yet, but will be, because that's a real long drive. The issue. All right, this is a Rios case. You'll talk with Mr. Francois. Bailey Cato.
Your Honor, so I spoke with Mr. Cato 2 weeks ago. He told me he was going to hire a private attorney. However, I do know there's, I believe, an active warrant for Mr. Cato as well.
There is, look at that. Okay, and this was transferred, but it looks like properly because he is a repeat offender. Okay, let me look.
Oh, really? Who's his attorney?
He did not turn himself in?
No,
Okay,
or also advised him twice.
he's got a probation issue?
He did.
Okay. Ms. Smith, bench warrant?
Yes, Your Honor.
All right, and good morning.
Good morning.
All right. Joseph Varner. In custody? No. Oh.
He will be mine if he appears, Judge. I don't have any working numbers for Mr. Varner.
Just been trying to figure out where he is, because the last thing I saw in the jail box that he went over to East Point PD in January. But after that, it's unknown.
Unknown. It said Foreign County. Now it may be in there, if it's East Point, they'd say there's not Foreign City. But he was transferred on January 6th to somewhere. You're saying it was East Point?
It's going on the public side, I guess, or East Point PD.
Okay. All right. This is not an old case, so Ms. Smith, another bench warrant?
Yes, Judge.
Assuming he's not stuck in custody somewhere. All right, we'll do bench warrant. Robin Johnson. is here. Good morning, Ms. Johnson.
She will be mine. I don't need to speak with her.
All right. Ms. Johnson, Ms. Wood is going to talk to you about your case, and then we'll have a conversation before you go about whatever's happening next, okay? Thanks. Kimberly Shalenge.
Good morning, that's my case. I believe we have an agreement with one.
So I saw something, but I thought it came from Ms. Smith, but I saw Ms. Willingham just raise her hand.
Oh, no, Judge, I was just putting my hand up. It's not me.
Oh, it's not you. So it is a Ms. Smith case. Okay. I need to take is she here or she's coming from ACDC? Okay, so Mr. Tiku, we'll wait for her to get here. And then we can talk about this supposed consent bond. Yes, okay,
Thank you.
sure. Wow, Ms. Smith, you were working early this morning. When did you get to work?
6:40.
All right,
It's not common.
okay, so we'll circle back to that. Carlos Jean-Pierre.
That is a probation revocation and we're waiting on that.
Rios, okay. Ready as in you think it'll resolve today?
Yes, we have an agreement.
Okay. Justice Ford, I remember Justice Ford.
He's one on ACDC.
She.
Yeah.
We don't have an agreement, but we can have their revocation hearings.
Okay. And then Daniel Jackson,
We're ready to go forward with the probation revocation.
is he ACDC or he's here?
He's here.
He's here, okay. Let's just figure out, we only have two more here. Tori Hughes.
I have not had contact with Ms. Hughes.
Let me look that one up. So I have Tori as a guy, but it's how he's listed. It was active in non-complex and just got bounced over here. So I guess I'm going to view it as good notice because he had been appearing in non-complex. So bench warrant, did you say you didn't have a good number or?
There was not in the file, but I'll reach out to whoever was representing him in non-complex to see if I can get him.
Okay, yeah, nothing in here. There's a street address. That's it. Older guy. I don't know that address. Okay. Christian Falconer. He. 1, 2, 3, 5. We're trying to sort out who represents Mr. Falconer. Guess he's not in custody, so he needs to be here. And I think there's been some confusion about who's going to represent him, but we'll do bench warrant. So let me recap. Dunn stays in non-complex. You will speak, Ms. Rios, with Mr. Francois. Maybe we can resolve that by shoplifting. If not, we'll do his arraignment. Bailey Cato, no show. Joseph Varner, no show. Ms. Johnson is here and she's walking back in, just spoke with her lawyer. Ms. Shalenge will be here and we'll talk about the consent bond. Mr. Tiku just stepped out. Carlos Jean-Pierre is here and that revocation can go forward. Same with Justice Ford, except I don't think Justice Ford is here yet, coming from ACDC. Daniel Jackson is here. We can do that one. And then we round it out with two more bench warrants, Tori Hughes and Christian Falconer. Anyone here who thought they had a case, didn't hear their name called? Yes, sir.
This is Travis Nelson, Judge.
Oh, I heard this is a walk-in.
Yes.
Okay.
Do you need the case number?
Please.
25 SC 002442.
Right. And Ms. Nelson had that on the calendar and I even looked it up before. Is this a probation? Maybe not.
Warrants set aside.
Okay, let me pull the file up. He was transferred from non-complex. We missed him on January 5th, and here we are.
Yes.
Okay. Why don't we deal with it now? Why don't you and Mr. Nelson come on up to the podium, please?
And Judge, I did also email, I sent the offer that the state sent on the P and A date. I just sent that again to Ms. Wood.
Oh, there was an offer to maybe work it out then, but we just didn't have Mr. Nelson.
Correct.
Okay.
Well, the judge, could we?
Take a break and talk about that. Yes. So, Mr. Nelson, we'll still talk, but this is an opportunity for you and Ms. Wood to work through. Maybe we can just resolve your case today. You're not obligated to do that. Ms. Wood will give you good counsel on that front, but maybe it's something that's resolvable today. So she's going to talk to you about that. We need to have a conversation one way or the other because there's a warrant, and unless I set that aside, you actually don't get to leave the way you came in. I'm not saying I won't set it aside. We certainly need to work through why you weren't here on January 5th. And it sounds, no, you don't have to tell me now. Ms. Wood's ready to talk about that. But more fundamentally, she wants to talk to you about, maybe we can just resolve the case.
Sure.
So when you guys are done talking, I'll bring you back in and we'll talk through both those things.
Sure.
All right. Ms. Rios, since Ms. Wood is going to be talking with Mr. Nelson. Oh, Ms. Rios isn't here. All right. Did she go? She went that way. Okay. She heard the fire alarm and ran. Hello. Hey, no one was pressing you, but we're gonna pivot to one of your revocations because Ms. Wood is talking to a client. What would you like to start with?
Let's do Carlos Pierre.
Okay, Jean-Pierre.
Yes.
Okay. Okay, let's get on the record, please. This is 09 SC 82327, State versus Carlos Jean-Pierre. Good morning, sir.
Good morning.
I'm Judge McBurney. I don't know that we've met before. Your case is, excuse me, very old. And my guess is you resolved it in front of a judge other than me. I'm very old also, just it wasn't my case back then. You have been on probation. You've got 8 years and a few months remaining on your probation. And I signed in September of last year a probation warrant that alleged you violated your probation by being arrested for family violence, simple assault, obstruction of officers, and terroristic threats. That all happened in early September. It sounds like that case is pending here, well, in state court. So in this building, I see a case number for it. So those charges are pending. But getting arrested for those kinds of things and getting mixed up in that is a potential violation of your probation. So I'm going to hear from your lawyer. You may have some things you want to add. I'll also hear from the prosecutor. Ms. Smith, are you handling this? Okay. And we'll go from there. So Ms. Rios, is Mr. Jean-Pierre stipulating to the fact that he was arrested for these charges? And I guess the terroristic threats got dismissed or downgraded if it's a case in state court.
Yes, sir.
Okay. What is it that you want to tell me about his situation and what is it that you're recommending?
He has 2 children. He was also working, 1 son and 1 daughter. They're adults, but he was working at Atlanta Rental Place before he got arrested.
What is that, Mr. Jean-Pierre?
Is where we set up for parties, events and stuff like that, stages and stuff.
So I would rent a tent and a stage and you'd be one of the guys who's
Yes, sir.
making it work.
Set it up for you.
How long had you been doing that?
I've been doing that for like 2 years.
Okay, so good gig.
Yes, sir.
All right.
He has struggled with alcohol abuse for years, so we've gotten him into Salvation Army. I have an acceptance letter here, and I will be doing a transport order for him. We're asking for him to be revoked for 5 months, credit for the time he served, with the agreement that he complete anger management within 3 months. This is the agreement between the state, and I believe the state and probation have agreed to this.
So we'd add a special condition of anger management. We'd add a special condition of enter into and complete Salvation Army. Is this their rehabilitation center on Marietta Street?
Yes.
Okay. That's 6 months to a year, that programming. So I'd say a minimum of 6 months of that. Mr. Jean-Pierre, I just heard you say you had a good job, you've got kids. This Salvation Army program, with which I'm familiar, is one that is at least initially residential. You are staying there. You're not able to, and you can do work, but it's work for Salvation Army for which you get, they call it a gratuity. You get paid for it, but you couldn't go do this rental work right away. You would be focused on your recovery. And if you said, I'm done with this, I'm going to go make good money with the rental business, that would be quitting the program, which would be a violation of your probation. So I just want to make you sure you understand the strings that come attached to this. They're good strings, I think, because they're helping you focus on sobriety. But I don't want you to be surprised when you get there and they say, hey, here's your bunk, and you're going to be with us for X months before you could go work on your own. Am I telling you things you've never heard?
No, I've heard it before. I'm fine with that, sir.
Okay.
I understand.
Good, okay. I just didn't want there to be surprises because Salvation Army is pretty good about letting probation know this guy quit, he took off, and then that would be a violation of probation. We'd be back here again, and it would be harder for Ms. Rios to say, you know what we need to do is get some programming for Mr. Jean-Pierre because you threw it in the can. Okay, thank you for sharing that, Ms. Rios. Ms. Smith, anything you want to add about Mr. Jean-Pierre or this revocation?
Not that far, Your Honor, just that we're all in agreement with the sentence recommended.
Okay. Ms. Simpson, anything from probation?
Judge, I just asked that, include that he completes anger management within the first 3 months of him being released.
Okay, and this would be a course as in one session or what, how do we know? Because like if this were family violence intervention,
I think anger management is one course.
Okay.
I think it's, understand correct, I believe it's like a full day.
okay,
He was originally given that condition and still had not completed it.
oh,
So, I'm asking if you would include that he needs to complete within the first 3 months.
okay. That's fine. I may say within the first 5 months, because if Salvation Army is keeping him close for, I don't know how long he'd be kept, but if for the first month and a half, he can't even get out of there, then that's kind of shrinking the amount of time he'd be able to go do this class. So I may make that a slightly bigger window, consistent with the support he'll be getting. Had Mr. Jean-Pierre had other issues while on, I don't, given his charges, I don't know when he got out, how long he's been on probation.
He has been on probation since June of 24,
Okay.
and this is actually his first revocation.
Okay. Got it. How long was your sentence?
15 years.
Okay. And it was armed robbery, so you did all of it. There's an alleged victim in this case, and we're not saying anything about part of your probation is stay away from or no violent contact or what. And I don't want to interfere with how that case is being prosecuted or how it might be resolved. Do you have any insight into that, Ms. Smith?
I don't, but I can look into it.
I just want to make sure we're structuring probation in a way that that works. Who is the alleged victim in your state court case? You don't need to give me the name, but is it a girlfriend or an uncle or a mother of your kids?
I got into it with the police.
Well, one of the charges was supposedly, and I don't want you to talk about the facts of your case, was family violence assault.
They said that, but mom called them though.
Oh, okay. But the big beef was allegedly you and the police got into it.
Yeah.
Okay, let me just look up your case and see what the. So the accusation is just obstruction of law enforcement officers, that you hindered Officer Serrano and Officer someone else. Okay, got it. That's all that is still in there. Okay. Do you have any questions about what we've been discussing, Mr. Jean-Pierre?
No, sir.
Have you received alcohol treatment before?
No, sir.
So if you got out of custody only in 2024, your struggles with alcohol have been since you got out?
Yeah, I've been drinking almost like a year. That's
Okay, but it's all post-release. I mean, the way you've been dealing with, haven't been locked up for that long and readjusting is you've been drinking a lot. Okay, so you feel like this treatment is something that you want, you need, and that you will embrace.
Yes, sir.
Let's give it a try. Well, Mr. Jean-Pierre, I find you violated the terms and conditions of your probation by getting arrested for these charges. And in light of that, what I'm going to do is revoke 6 months of your probation. You will get credit for the time you've been in, which is, one second, pretty close to 6 months. I just want to leave time. Oh, you've done 183. This calendar was published a while ago. You did 6 months, 3 days ago. So I'm not gonna, you will be released with a transport order so that you get delivered to Salvation Army. So even though the 6 months is up, you're not getting out today. We want to make sure the bed is ready and either Salvation Army picks you up or someone from the public defender's office picks you up. And you'll go there. And I'm adding as a special condition of your probation that you complete an anger management course within 6 months. Also, I will waive your probation supervision fees for the first 3 months because you're not going to be earning as much as you were when you were with a rental company, when you're still doing the work at Salvation Army. Soon enough, they want you to be out in the world earning a good keep, but early on, that's not the case. So I'll waive the supervision fees. And I think that's it. Ms. Simpson, what reporting instructions does Mr. Jean-Pierre have?
It would still be within 48 hours, if he is on a restricted confinement, once he enters Salvation Army, then it needs to be 48 hours once he is permitted to leave.
Okay. And I don't want you to be alarmed by the word confinement. The Salvation Army can't keep you. You can always walk away, but they may say, and I'm making this up, for the first 2 weeks, we don't want you leaving the facility because we are focused on you and making sure there's no alcohol going in your system. They may say, hey, you got to go to probation. You can go do that. But if they say, no, you can't, you're not getting sideways with probation. It's as soon as Salvation Army says, Mr. Jean-Pierre, you can go check in with them. You need to go do that. You already have an officer and you're just going to be reconnecting with that office. Maybe not that officer. They may assign someone else. but you certainly, you know where their office is?
Yes, sir.
Near here? Okay. All right. Anything else, Ms. Rios?
No, Your Honor, thank you.
Ms. Smith? Okay, Ms. Simpson, you got it? Okay. Any questions, Mr. Jean-Pierre?
sir.
Good luck with things. How old are your kids?
My kids, 22 and 19.
I guess they gotta be kind of old, given that you were away for a while. All right, what are they doing?
What are they doing? My daughter work at Taco Bell, my son work at UPS, they work.
All right, good for them.
All right.
See ya.
We can do.
So we had a couple folks walk in. I want to just revise so we can clear up some potential bench warrants. You, sir, are?
Douglas Dunn.
Douglas Dunn, fantastic. I don't know why you got noticed to be here today, but you did, and I'm glad you're here. Your case is still in non-complex. And I can't remember if that means Judge Mao or Judge Brooks.
It's non-complex too, I hear.
It's non-complex too. You probably met the judge. Do you remember who the judge is? It's okay if you don't. You're still in non-complex. And so the judge who handles that, and that courtroom kind of moves around some, but you are staying there, which is a good outcome for you. I don't have a good explanation for you as to why you got noticed to be here today. Your case was not transferred to me. I'm Judge McBurney. Nice to meet you. But I'll tell you who your judge is. It is Judge Brooks. Judge Brooks is the non-complex 2 judge. And you remain on track in there. You have a pretrial conference on the 11th, so 8 days from now. If you've got notice for that, show up for that. You're welcome to come visit us anytime you want, but your case is not here. It would just be to say, hey, Judge, what's cooking? Okay? Is Ms. McCoy a colleague of yours? Who has a public McFoy, Ms. McFoy?
Yes, but I think she left the other leave, so I'll talk to her.
Okay, so Ms. Wood is a colleague of your lawyer in non-complex, and she's just gonna let you know what's going on. I apologize for the confusion. I appreciate you coming here. I hope we didn't disrupt your day too much. Again, I'm not sure how it got bounced over here, okay? All right, and you, sir, in the red, oh, no, I know who you are, red. Say it again, Mr. Varner? Great. Mr. Varner, Ms. Wood is going to talk with you. Have you already talked with him?
Speak, but I was going to speak to the state.
Okay. Okay, so I need you to sit tight. You and I and your lawyer and the prosecutor will talk in a little bit. Ms. Wood is trying to figure out maybe there's a way to resolve your case today. If not, we're going to at least handle your arraignment, okay? All right. All right, Ms. Rios, Ms. Wood is popular today. So are you, but she's busy. So let's do another one of your revocations.
Okay, I guess we can do Mr. Jackson.
All right, please. Any update on AC/DC? Okay, so when we take a break, we'll bring your client up and we'll tackle that. Oh, I trust you'll put on the revocation order. I forgot to mention the most important special condition, that he enter into the Salvation Army program and complete at least 6. It's the same thing. He's gonna be with Molden. Molden is going in the same place. That's how I was able to, it's 6 months. It's on Marietta Street. And you think that order will work?
I think so.
Okay. I talked to another judge who has revoked a suspended sentence with just an order that had paragraphs in it as opposed to a final disposition that converted some of it into probation.
Yeah.
And as long as you guys get it, you're like, yep, okay, he's got 1 year and 5 months on probation.
For the harbor, we wanted, to be probated.
Yeah.
That I would do that.
Okay, good. If it needs to be something different, let me know.
So they're acting.
Thank you. Ms. Simpson knows this, or that's how you know it? Okay.
She's asking for a year to be revoked.
Yeah, because it's not showing here, but it's good.
The judge.
Okay. All right.
I mean, like I said,
He's been busy
yeah, this is, I mean, I had.
stopping the fire alarms.
Yeah, I think it's,
We'll talk.
okay.
All right, Mr. Jackson, give me 1 second. I'm just pulling up your information. There you are. Okay. All right, let's get on the record. This is 25 SC 000706, State versus Daniel Jackson. Mr. Jackson is here with his lawyer, Ms. Rios, and Mr. Jackson and Ms. Smith is handling this for the state. Nope, Ms. Willingham is handling it. All right, we've got Ms. Willingham for the state. Mr. Jackson, you pled guilty to an aggravated assault charge not all that long ago and were given probation. In October of last year, there was some information provided to probation that you had allegedly sent a threatening text message to Ms. Jackson, who was the victim in the aggravated assault case. That led me to sign a warrant in January of this year, and we're here to work through what's going on and should there be consequences for that text, et cetera. I'm going to hear from Ms. Rios. There may be things you want to add. Ms. Rios will let me know if there are things you're going to share. I'm going to hear from Ms. Willingham. I've got a little paperwork about this situation involving Camiata Jackson, and we'll figure out what we're going to do, okay? Ms. Rios, tell me Mr. Jackson's posture. Is he admitting that this happened or?
According to the arrest.
Okay, so he was actually arrested?
I believe so. Was he-
Were you?
Yes, yeah, I had no warrant. I mean, no heads up about the warrant. I never knew I had a warrant until.
Okay, but I want to make sure I'm understanding to what you're stipulating. Do we know, was Mr. Jackson arrested on the probation warrant or did Ms. Camiata Jackson call the police and Mr. Jackson was arrested because of her call? Those are two different
Okay,
things.
I thought he was arrested on the probation warrant, but maybe I was mistaken.
Yes, that's what they told me when I was arrested. It was a probation violation.
Okay. So he's stipulating to the fact that he was arrested on a probation warrant.
Yes.
Okay, all right. But
We,
why don't you talk through what you want to talk through? Because I don't think being arrested on a probation warrant is a basis to revoke. It would be why he was arrested. And this one is a little different. I mean, the previous gentleman, he was arrested by law enforcement for separate charges. And there's this situation, a supposed text message to Ms. Jackson. Ms. Jackson she's the mother of your children. Is she also your spouse, or it's a coincidence you have the same last name?
Oh, no, it's my wife.
It's your wife. Okay, so we're talking about your wife. I can use that for shorthand. Your wife contacted law enforcement, got a report from the Fulton County Sheriff's Office. And so is she in Detroit? Okay. And I guess she reached out to the sheriff's office. They then provided information to DCS probation, which empowered them to get this warrant. All right.
yes, Your Honor. So he has had, from my understanding, besides the situation, I think they were in some type of argument. I didn't see the text messages in the report, so I'm not sure exactly what he said. From my understanding, it wasn't anything like he's going to kill her or harm her. I think it was some type of like vague, and maybe he misunderstood as far as like when someone hears no violent contact, he hadn't hit her. He's not alleged to have made any physical contact with her. I think it was a heated argument, but from my understanding, I'm not sure because I haven't seen the text messages. It was nothing about you just got them? Yeah.
Ms. Willingham has them. Do you want to, are they emailable? Because I could put them up on the screen.
I can email them.
Okay.
But just while she's doing that, some background. He's 35 years old. He started since he's been on probation, a box trucking company.
You started the company.
Yes, sir.
All right.
He did that in 2025. He has 2 children, a 7-month-old daughter and a 9-year-old son. And so he's been in for 30 days. And so we're asking for him to be revoked for 30 days and reinstate. So he can continue to provide for his children and make money with his company. And I know this is your decision, not his, but he is fine if it's moved to just a full non-contact.
Okay. Let me.
I mean,
Oh.
So can you see on the screen? Let me know when you've read it. I'll take it down.
Mm-hmm.
Okay. Mr. Jackson, is that something you sent to Ms. Jackson?
I'm not aware of all that stuff. No, man. I mean, no, sir.
Does that not,
I mean, no, I'm not.
you're saying no way that happened, or you're just not necessarily remembering if you guys had an exchange like that?
I remember a change, but I don't remember them text messages, no.
Okay. Your, thank you. 2 children, 7-month-old and 9-year-old. Are they with Ms. Jackson?
The 7-month-old is.
The 7-month-old, and is that a daughter?
Yes.
So that would be the her or the she that's being referenced in those texts. The 9-year-old is a boy or a girl?
This is my son.
Your son, and he's local?
No, he's in Detroit as well.
With Ms. Jackson?
No.
Okay, with someone else?
Yes.
You're originally from Detroit?
Yes, sir.
Okay, and you have 2 kids up there, one with Ms. Jackson, your wife, and that's the youngest.
Yes.
And the older one is with his mom?
Yes.
Okay, and so none of this is about your son?
No.
Okay. What are your financial obligations as you understand them to help? So what's your daughter's name?
Kamada. Oh, my daughter, Kamada.
I'm gonna just call her your daughter because that's gonna get complicated on the record. It's a beautiful name, too close to your wife's name. What is your understanding that you have with your wife about how you are financially supporting your daughter?
Like I said, it was just, like I said, give her, like I said, it's $800 to $1,000, like I said, where I can just go ahead and buy stuff for her. So that's what I was doing. I was sending her money, like I say, roughly about $1,000 a month.
Okay.
And then, like I say, I want to buy stuff for her as well, but sometimes she don't allow me to. She just want the money instead.
Okay. And is that an informal agreement, or is there some court order that says Mr. Jackson needs to pay $1,000 a month?
That's something I came up with.
Okay. The 2 of you agreed that was a pretty healthy support for your daughter?
Yes.
Okay. Do you know if Ms. Jackson works in Detroit?
I'm unaware right now. I believe she did probably start a job, but I'm unaware right now.
Okay. All right. Ms. Rios, anything else you want to add?
No, Your Honor.
Okay. Ms. Willingham, tell me your thoughts about Mr. Jackson and Ms. Jackson's situation. And you had a little more info.
Yes, Judge, and I just got those text messages. I know Ms. Rios asked for them earlier, so I Ms. Jackson to get that information.
Mhm.
When I spoke with her, Ms. Jackson just wants it to go back to the no violent contact that it was. She does not necessarily have a desire to see the defendant in custody. I know what probation is asking for, and I told Ms. Rios that I'm going to agree with probation. However, I would let the court know that Ms. Jackson feels like things were going fine up until this point, and that she believes they can go back to that. And she mentioned several times during our conversation that she did not want to see the defendant in custody for this, just that she wants him to understand that this is not going to lead to a healthy co-parenting situation.
Okay. Did she express any concerns about, the part I'm trying to work through is the no violent contact. She didn't ever share with you a concern that Mr. Jackson was showing up in Detroit, banging on the door. It would be, we could call it abusive or unsupportive language in texts, maybe phone calls.
She was not aware that he was back in Detroit, is what she explained to me. She did not know that he would be able to leave the state. I explained to her that that's a conversation that happens between him and his probation officer. So we're not always made privy to whether or not he's there. So I did explain to her that, and she said that now that she understands that better, that also kind of allows her to navigate the situation a little differently.
Okay. I'm just trying to follow the notion that what we're describing here was violent contact. And I know that's an elastic term, and I'm not trying to minimize the way it may have been upsetting for Ms. Jackson. But I also, if Mr. Jackson hasn't left the state of Georgia, then it sounds like it may have been language that he might need to dial back despite being frustrated. But it's not, and I'm being traditional here, but it wasn't he's scaring her by banging on the door or he threw something.
Based on my conversation, it does sound like they may have actually seen each other, but not that she felt the contact in person was necessarily violent. This text message was her concern. She just appeared to be surprised that he was there.
Okay.
You don't, for the record, you don't have to.
Right. Well, we're going to talk about that. We'll get there because we need to make sure you understand the ground rules. You want to see your kids, your restrictions on travel, things like that. You've got a fair amount of probation remaining, and you don't want that to come tumbling down around you, especially if you're trying to get a business off the ground. Okay. What is your recommendation, which sounds like is probation's recommendation?
Yes, Judge. Probation is asking for revoke a year and then reinstate the balance, and the state would agree with that recommendation.
Okay.
And I did express to Ms. Jackson that I would be asking to revoke some time.
Okay. And Ms. Jackson is saying she doesn't see the need for that. Ms. Rios is asking for 30 days, which would be 3 more than he served, and state is saying a year. All right. So Mr. Jackson, have you left Georgia since you've been on probation?
I haven't.
Okay. You're not going to get in more or less trouble right now because it's not alleged that you left Georgia, but I just need you to understand that if that was in the plan or it is the plan, you actually need to get permission from probation first to go outside of Georgia, even as for work. If you got this box truck company and like, hey, you need to deliver something to Gadsden, Alabama, you can't. You would need to get the green light to say, here's the contract I've got to get something to Gadsden. Can I do that? And probation would probably say yes, but crossing state lines is a violation of probation absent approval in advance, not it's okay that you did it after the fact. So that would apply just as much as I want to go see my kids and I'm going to reconnect with their mothers in a peaceable way. Those are good things, you being around your kids and having nonviolent contact with the mothers of your children. But again, probation would need to sign off on you leaving the state. And typically they will, unless there's a concern. There may be a reluctance to say you can go to Detroit because of what we're working through. But my example of I'm making a delivery into Alabama, typically probation would say, that's fine. We just need documentation. Here's the contract. Here's the delivery point, that kind of thing. But you need to keep that in mind. If it comes to light, it's pretty easy to figure this stuff out with phones and cell phone towers and whatnot. If you left the state, that's the kind of thing probation might bring back to say, we don't even know where this guy's going. He's leaving the state. You understand that?
Right.
Okay. Ms. Rios, anything you or Mr. Jackson want to add?
No, Your Honor, I just still working through that. I don't believe this was necessarily, I don't know. I think the definition of contact is a little, maybe I'm just not sure of the definition, but it seems a little gray to me of what, if this was, maybe that just needs to be re-explained so he understands like what it means that violent contact is. Because I think in the heat of the argument, he didn't believe he was violating his probation.
Well, I want to be clear, he's not by having contact. The special condition was not no contact.
Yes.
I'm looking at it right now, it was no violent contact. And so I think where we are struggling a little bit is how elastic is the term violent. I would probably agree more with you that it would be, it's this tumultuous behavior in front of someone, shoving them or maybe pounding on the wall next to them, but not, assuming you sent those texts, and it makes sense to me, it sounds like that's an interaction you're having with your wife. I mean, he's frustrated and that shows here, but I don't know that that would fall into the category of violent contact. It's trending in the direction of I'm mad, and so I could see why Ms. Jackson would be concerned. But if she, and it sounds like Ms. Willingham says that Ms. Jackson wants to continue to have communications with Mr. Jackson, then they're just going to need to develop a way to text and call and whatnot where they keep the frustration level a little lower. A couple more questions for you, Mr. Jackson. You were supposed to, as part of your probation, and it's been a bunch of months now, you were supposed to do family violence intervention program. And?
Okay, now I haven't started, but I know, I said she said I had 6 months to wait, get everything. I said, get a job and all that stuff. That's when I started my thing, but I did let her know that I was gonna start it up this year and doing, but like I say this incident happened before I can even start the front of the classes.
Okay, and you're supposed to complete something called Family First.
Yes.
Done that yet?
No, I haven't done any of the program there. I told her I was gonna start this year, like I say, because I know I had the 6 months to get all my affairs in order.
You did. That was November. So now you got your affairs in order.
Yes, sir.
Okay.
And like I said, this situation came up before I can sit down and get them done.
You were also supposed to have a drug and alcohol abuse evaluation. Did you do that yet?
Yes, I have done that.
Okay, and what'd they say?
Well, I said I gave my probation. I went over there, gave her the list, and she said everything was fine. I guess I had no drugs. I said I don't use drugs anyway.
Okay, so they didn't say you need to get some counseling or anything like that?
No.
Good. Well, let's keep it that way. All right. Mr. Jackson, it is important that you figure out a way, and the Family Violence Intervention Program is going to help with that, to regulate your emotions when you're dealing with Ms. Jackson. It's going to be frustrating. You're going to feel like she is using your child as a pawn, a way to get at you or extract money from you. I'm not saying she is doing that. I'm not taking a side here. I just see this dynamic, and it can prompt the person who does not have access to the child to get angry. You don't have that luxury. At least you don't have that luxury with Ms. Jackson. You may get angry and then you need to go boxing or go for a run or yell, not at Ms. Jackson, but you need to figure out a way to channel whatever negative emotions you have because of the way you and Ms. Jackson are interacting away from Ms. Jackson. Because if there's a situation like this again, it's going to make me think more and more, we're on the verge of you being violent. I don't find this to have been violent. It was angry, but anger and violence are two different things. If the anger turns into you swing at her, you throw something at her or whatnot, then we've got an issue. But it doesn't sound like you're there yet. I don't know if you went to Detroit. Do not leave Georgia without getting permission from the folks at probation. If Ms. Jackson shoots us a picture, meaning to Ms. Willingham, of you with her and your daughter, that means you were in Detroit. And if you didn't get the green light from probation, they will appropriately be coming back to me to say, hey, Mr. Jackson doesn't get it. I am going to revoke 2 months of your probation. You will get credit for the time you've served. I will reinstate the balance, and I'm modifying the conditions of your probation as follows. You need to enroll in the Family Violence Intervention Program in the next 3 months. Similarly with Family First. Your probation supervision fees aren't waived anymore. You had those first 6 months. It sounds like you used them wisely. You started up a company, et cetera. But when you get out, it's going to be time to get into those programs and start benefiting from them. If we look back at what got you into this mix to begin with, it was some serious charges: aggravated assault, battery against a pregnant female. Your lawyer worked hard on your behalf. The prosecutor was reasonable, and you got a sentence that kept you in custody for only about 90 days. But you can understand, hopefully, why the prosecutor and why I am a little nervous when I see a text like this, because it's you being angry again. Again, anger is not the same as violence, but you're going to need to figure out a way to coordinate parenting long distance with someone who may get on your nerves. Okay?
Yes, sir.
I want you to stay in your daughter's life. I think that's important for her, but you're going to need to figure out the way to do that safely for you. Any questions about any of that?
No, sir, I just appreciate it.
Okay, well, let's turn the corner on some of this. You enrolling in these things, I think, will help a bunch. Ms. Rios, anything else on behalf of Mr. Jackson?
No, Your Honor, thank you.
Okay, Ms. Willingham,
Nothing further, Your Honor.
you'll let Ms. Jackson know?
Yes, Judge, and I am sending Ms. Rios enrollment papers for Family First so that he can get the paperwork filled out.
Great, that's through your office?
Yes.
Okay, good. Ms. Simpson, anything he just needs to re-report when he gets out? Will he still have officer, I can't read it on this.
I gave him.
SR
I gave it to Ms. Rios to give him.
24
at
gmail.com.
Yeah. Angelica,
Yes.
yes,
Well, you revoked 2 months, so you did
Great.
7 days, then you have the remainder to the end, and then you'll be.
okay, and then it may be he's reassigned, but start by reaching your officer.
Like 2 for 1 time for that credit.
Don't know, that's up to the jail,
Okay.
so maybe, maybe not, you just have to see what the jail is.
Okay.
Mr. Jackson, when you get out, and you will stay here, you're not going to the Department of Corrections because the sentence is short enough. When you get out, make sure you call your probation officer. Say, I'm out. You're not going to move. I got an address for you on Ponce.
Yes.
That's, excuse me, still your address? Okay, and you better keep it, even though you're going to be locked up for a little bit?
Yes.
Okay. You got to call your probation officer within 2 days of being released and say, I'm out. How do I plug back in? Okay?
Yes, sir.
Any questions?
No, sir.
All right, good luck.
All right, thank you.
I think Mr. Cato? Bailey Cato arrived.
Yes, Judge. You can just confirm, when I spoke to Mr. Cato, weeks ago, he told me he was hiring private counsel.
Okay. Mr. Cato, I'm Judge McBurney, and we need to work through a couple things in your situation. One of them is representation. Another one Deputy Gordon is working on. Do you plan on hiring a lawyer, or do you want me to appoint a lawyer to represent you in your case?
Yes, sir.
Well, it was an or question. So you know whether you've got the funds to hire someone or if you need appointed representation. I don't. You tell me. Okay, well, that's Ms. Wood, who is the senior PD in here, public defender. She's going to talk to you a little bit about the case and we'll figure out what we're going to do today. I want to be clear, you are always free if you decide later on down the road you want to hire a lawyer and you have the means to do so, you can do that. But we always have lawyers available, skilled lawyers available for appointment, and that's what we'll do with Ms. Wood and your case. All right? I think we're going to pause for a moment because I think you need to confirm a couple things, Deputy Gordon. Or is someone doing that or you need to do it? Okay. All right. So we now have Mr. Cato is here and Mr. Varner is here. And you're going to confirm a few things and then we can pick up. I guess while he's doing that, if you have something that's just a plain old announcement,
Yes.
you could knock that out.
We can handle position 5, Ms. Johnson.
All right. Hey, Ms. Johnson, if you'll come up, you actually stay right there. As long as you can hear me, let me get your case up here. Number 84. All right. What are we doing with Ms. Johnson?
I'll just announce not guilty today and I'll file a waiver.
Okay. Ms. Johnson, Ms. Wood is waiving arraignment for you, just meaning she's saying for now that the plea is not guilty. That starts the process going whereby the prosecution will get discovery to your lawyer. That would be a police report, or if you gave a statement or someone else gave a statement, you'll get all that. Then Ms. Wood will meet with you and you guys will figure out if there are any motions that need to be argued, and then I'll see you for that. Or if you're resolving your case, I'll see you for that. I've got an address on Lone Oak Avenue. That's still a good address? Okay. Did you give your phone number to Ms. Wood? Okay. Did she give you a phone number? Excellent. Let me check one other thing. You have a bond, and the main condition is you got to stay away from an address on Cascade. Do you know the address I'm talking about? And you need to stay away from someone only known as CJ. I guess that's a kid. You know who I'm talking about there? Okay. Does that present any issue, or you're able to do that while we're working your case out? Okay. If that needs to change at all, I don't know if CJ is related to you in some way, let Ms. Wood know and we can talk about modifying the bond. But until the bond's modified, you stay away from that address and you have no contact with CJ. Okay? You also have an ankle monitor on, but the county's paying for it. Okay. All right. If that needs to change, talk to Ms. Wood about that. Okay? Anything else, Ms. Wood?
No, Judge, thank you.
Is this going to be a Willingham or a Smith case? Okay. Anything from the state? You'll get discovery rolling? Okay. Ms. Johnson, any questions? Okay, you're good to go. Thanks for being here. So we're going to take a quick break. Deputy Gordon is checking on two things, and I'll have him bring up, I think our ACDC inmates are here, so we'll have them brought up, and we will work through those as well. Unless, Ms. Rios, you've got any announcements.
No, I just need to talk to Mr. Fran Boyce. I'm pronounced that name.
Mr. Francois?
Boyce, yeah.
Okay.
I need to talk to him and see if he can resolve, please.
Okay.
Judge, if I may.
Oh, yes. Hold on one second. I forgot I saw you, Ms. Green, on the call. Just updating my calendar here. Good morning. How are you?
Good morning, Judge. I'm doing well, thank you. Apologies, I was in a probation hearing this morning.
Me too. So you were maybe the lawyer for Christian Falconer, but he's not here. He didn't show.
Okay.
I'm currently here, Judge.
Oh,
I was
he
in
is
a
here.
Zoom link this morning. I thought court was suspended. That's the notification I got in the mail.
Okay, wait, we got everyone we need. So there's Mr. Falconer, there's Ms. Green, and we also have in the docket a motion to withdraw from, let me get back into the case. From you, through Michael Barber and Associates. Is that still an active motion?
That's correct. Yes, Judge. Mr. Faulkner was given the intent letter on December 31st.
Okay, so Mr. Falconer, that's what we need to work through today. You were on for inquiry. I asked that my staff put this on a calendar. I am reluctant to let retained counsel withdraw from a case before I have an opportunity to hear from both the client and the attorney. But Ms. Green and her firm have made pretty clear their stance, which is that they think it's appropriate to withdraw. If you have not met your financial obligations with them, then I probably do need to let them withdraw. And then I need to find out from you if you have the ability to retain other counsel or if we need to get appointed counsel. So why don't you tell me what you think is going on?
I do, Your Honor. I was moving. I returned back to Georgia. I was working in Colorado, so I'll be returning to counsel. They can withdraw from the case.
So that came out real quickly, I think, because maybe the internet's not great where you are, the Wi-Fi. You are saying they can withdraw and you are going to be hiring counsel?
Yes, Your Honor.
Okay. Do you know who that counsel is?
I have 2 meetings today that I'm able to attend, so I'll be able to inform the court. Will I be still required to attend on the 10th, or is this count as the meeting for the 10th?
I don't have anything on the 10th. I've got today. The next event is the 21st for final plea in your case, but that's April 21st, which is plenty of time for a new attorney, meaning the next one you bring on board, to get involved. When do you intend to have hired new counsel?
Of March.
Pardon me? I need you to get to a spot where we can hear you. We can't hear you.
Can you hear me now, Your Honor?
Yeah. Can you be stationary for a second?
Absolutely. It would be the 14th, Your Honor.
It would be when?
The 14th, March 14th.
March 14th, a lawyer will file an entry of appearance on your behalf.
Yes, sir.
Okay. That's a Saturday? Any reason you picked that day?
Well, that should be that Friday before. I thought that was the Friday. I apologize.
That's okay. Friday the 13th. So I will make a note here that you should have counsel, new substitute counsel, by Friday the 13th of March. That person will then coordinate with the prosecutor, ideally get the case file from Ms. Green. She should surrender that to your substitute counsel, and then we'll move forward towards final plea. You need to let my staff know if there's a hiccup and you're not going to be able to have substitute counsel in place by the 13th.
Okay, absolutely. On that notice as well that I received in the mail, Your Honor, so I should ignore that for now and show up the April 21st, you said?
So I don't know what notice you're talking about. I don't have anything showing in the system that you had court a week from now.
Judge, Mr. Faulkner, it may be for Cobb County. I would double check that.
It's from Carson. Carson told me February 10th. He texted that to me.
Okay, we'll double check if it's for Cobb or for Fulton for you.
Thank you.
All right. Yeah, I've got you down as April 21st, and by then you should have substitute counsel well in place. Ms. Green, anything else?
No, Judge. Would you like me to issue a order or proposed order, or just wait for the substituted counsel?
No, if you would send in Word format a proposed order to Ms. Nelson, then I'll take it from there.
Absolutely. Thank you, Judge. And that
Miss-
would be all.
Okay, Ms. Smith, anything from the state? All right. Who represents, let me take a look here. The co-defendant, Ms. Golding is retained counsel? That's not a public defender? Okay. All right. Mr. Falconer, we'll look for this entry of appearance in, at the end of next week.
Thank you.
All
Thank
right.
you,
Thanks,
Judge
Ms.
Merritt.
Green.
Thank you.
Bye.
Have a good day.
Bye. It's a mysterious case.
Judge, before you step off the bench, as to Mr. Nelson, we are close, but not quite there. There's some mitigation that defense is gonna be getting to me. But with that, the state would consent to reinstate. I don't know if Your Honor still wants to talk to him, but I did want to at least let the court know where we were.
No, let's take care of that. If that's your last thing, we'll do that. And then we'll take the break to get other people up here. Mr. Nelson, come on up to the podium, please. All right, first things first, I want to make sure we've got a good address for you. I've got apartment E7 on Old Hapeville Road.
Yes, sir.
That's a good address. Okay. What happened with court in January?
Sir, I appeared the last time in court via Zoom. I lost my contact, so I will tell you who my public defender there, but I've been changing up so much. And when I was on Zoom, the attorney, I think it was Haglesbury.
Not sure.
I got Amy Cole was the name listed, but either way.
Okay, yeah, and they told me that I was going to be out of non-complex and entering into new complex, but that was going to be done on February 19th of my birthday, and that was my court date that they scheduled then. I had no idea there was another one in between. The attorney didn't let me know. I didn't get any notice. I didn't know there was another one in between that time and February 19th. So when February 19th call came, I called the judge's chamber of the judge I was supposed to have, and then then Miss Woods reached out to me and told me, oh no, that was the court date, but we'll get you in here to figure it out. But I definitely want to come to court. Wasn't trying to miss it or screw myself up in any type of way.
Okay. Well, if we've got good contact information for you now, which it sounds like we do, you did get transferred out of non-complex based on your criminal history. So we'll work through what's next. Are you on probation now? Some of these cases are not very old. Are you on probation?
I am on probation, yes, sir.
Okay. Any issues with probation that you're aware of, Ms. Simpson, for Mr. Nelson? Okay. Keep reporting to probation. And one last thing I want to check in this case. This is an old case. Your bond has as a condition, you got to stay away from an address on Armour Drive and a gentleman named Ryan Hickman.
Yes, sir.
You know who that is?
Yes.
You're staying away from him?
Yes.
Okay, good. Keep doing that. All right, I will set aside the bench warrant. That was your one set aside. Don't miss court in the future. Stay in touch with Ms. Wood about what's happening. I guess we'll need to do a scheduling order. I mean, he's been a.
Did I file a waiver recently?
No, he waived arraignment in non-complex, so he doesn't have to re-waive. In October of last year, Amy Cole waived arraignment for Mr. Nelson in non-complex. That waiver carries over, and I'm assuming she got discovery, but I guess just coordinate with Ms. Willingham. And we will do a scheduling order, but it will basically have a motions deadline, and then we'll move from there. Okay? All right. Any questions, Mr. Nelson?
Oh, no, I was just asking when the next time I come to court, so I know.
Yep, we don't know yet.
Okay,
She'll let you know.
okay, thank you.
You're free to go.
Thank you.
All right, have a good day.
Thanks, Judge.
And Judge, that concludes my business. May I be excused?
I figured that's why you brought this up. Yes, ma'am.
Thank you.
All right, we will be back in session in just a couple minutes. Just have Deputy Gordon grab me when he's back with that info, although I think he's also bringing a few inmates. Is he doing his research now or is he getting inmates? Research, okay. Thank you. So we have left Ms. Rios, Mr. Francois is up, so maybe you could chat with him?
Yes.
While I'm off, we'll bring Shalenge up. And that'll take care of Mr. Tiku. Ms. Ford will be brought up. And then we have our two late arrivals, Mr. Varner and Mr. Cato, I think, to work through. Mute the podium. Okay. And Mr. Cato went away. Is
He's
he?
in the hallway.
Okay.
We are, we're talking. Stand right here.
I'm just pulling your case up on my screen, Mr. Varner.
Yes, sir.
Good morning to you.
Good morning as well.
All right, so we were a little worried at first. You weren't here when we called the calendar, but you made it. I want to figure out what we're doing. Your case was in the non-complex division. They transferred it here because of your criminal history. Ms. Wood is going to be handling it going forward. Are we waiving arraignment today?
Yes.
All right, so Ms. Wood's going to fill out some paperwork that basically enters a not guilty plea for you. I will get a scheduling order entered that will obligate the prosecutor to get discovery to your lawyer, police reports, whatever they got. So Ms. Wood can talk to you about it and give you her sense of, shh, they got you on video versus, no, look, this is a great case. We're going to file a motion to suppress or whatever she thinks is in your best interest. I need you to show up on time for future court appearances. The address I have for you is on Hiawassee Drive.
Yes, sir.
Is that your place?
No, my grandmother's.
But you stay there.
Yes, sir.
Your grandmother lets you stay there.
Yes, sir.
If we mail things there, that'll get to you.
Yes, sir.
Okay. Do you have a phone?
No, I have a home phone.
Whatever numbers can be used to reach you, did you give those to Ms. Wood?
Yes, ma'am. Yes, sir.
Okay, good. One other thing, you got a bond in October, and that bond says that you need to not go into CVS stores. Guessing that's where the alleged shoplifting happened. So you're staying out of CVS?
Yes, sir.
Okay. Make sure you keep doing that. You have questions about anything else?
No, sir.
Ms. Wood, anything on behalf of Mr. Varner?
No, Judge, thank you.
Ms. Smith? Okay. You will get notice as to when you need to come back to court. It'll be mailed, but Ms. Wood will also, or someone on her team will also be reaching out to her. Did you get her number?
Yes, sir.
Call her if you've got questions. Okay?
Yes, sir.
See you around.
All right, thank you.
Bye, Mr. Varner. Yes. Oh, okay. Yeah, no, she's back here.
Deputy Gordon, is Ms. Shalenge up?
Yes,
Do you need to talk to her or can she come on out?
she can come on us.
Can we bring her out, please?
No. Hi, how are you? I'm good. How are you doing?
Oh, wait.
Hey, how are you? You talk to your mom?
Yes.
Excuse me.
All right, let's talk a little bit. How do you pronounce your last name?
Shilenge.
Shilenge. Good morning, Ms. Shilenge. I'm Judge McBurney.
Hello. How are you
Your
doing?
case has been assigned to me. I've been speaking with Mr. Tiku a bit about the case. And I see that he and the prosecutor, Ms. Smith, have agreed to a consent bond order. I've got a few questions for the folks involved and then we will figure out how we're moving forward. You're also here for your arraignment date. Mr. Tiku, is Ms. Shilenge waiving arraignment?
Oh, yeah, Judge.
Okay, I have a waiver of arraignment form that I'd ask you to fill out before you leave
Yeah,
and leave that with Deputy Gordon. We'll get it e-filed, okay?
Okay, Judge.
But if you do that, that'll take care of the arraignment piece. Ms. Smith, I'm actually going to start with you. Judge Oliver in January, just over a month ago, denied bond for Ms. Shilenge, saying that she posed a significant threat to the community or to people in the community. And now the state is saying we consent to a $10,000 bond. I just want to understand either what's changed or something has changed, because my guess is that the state wasn't telling Judge Oliver, no, don't deny bond. What's going on with the case?
Well, in this case, I got a chance to speak with the victim, got a chance to speak with the victim's mom also.
So there's a Nathan and a Sheila,
I spoke with Sheila.
and Sheila is the mother of Nathan?
I don't believe so. I think that it is her nephew, but that's not his.
Okay.
Nathan is not Sheila's.
Nathan is connected how to Mr. Tiku's client?
That's her nephew also.
Okay, and then Sheila is another, they all have the same last name, is another relative.
Sheila is the defendant's sister.
Okay, you agree with that?
Yes.
Got it. But Sheila does not happen to be the mother of Nathan?
That's correct.
Okay, all right. And you spoke with Sheila?
I did.
And based on that?
She expressed that she does not have an issue with her sister. She would ask for no violent contact, but she doesn't mind being around her sister. And she does not believe that she poses a significant threat. Also, when it's a this decision on doing a consent bond, is looking at the criminal history of the defendant, which the state believes is not violent, or it's not a lot of cycles. And it doesn't create a concern for the state that if the defendant is not on bond, that she will defend or is a flight risk.
Okay, it looks like both, based on your conversations, both Sheila and Nathan Shilenge have said, we're okay having Kimberly around as long as it's nonviolent contact.
That's correct. I spoke with Sheila.
Yep.
Nathan, to my understanding, is like 16 or 17. So I was able to speak with him.
Okay.
But speaking with me, she did express that she was not concerned if the defendant was let out.
Okay. And Mr. Tiku, where would your client be living with either of these people if she's released on bond, or it's just that she would be able to interact with them?
She'll be able to interact with them. She has her own place.
Okay. I have an address, Ms. Shilenge, of Worthington Hills Trace. Is that where you'd be going back to?
That's my mom's.
That's your mom's. Is that where you would be staying?
Yes,
Okay. And does your mom know that you'll be getting out soon?
yes,
And she says it's okay for you to stay there?
yes.
Is that where Sheila lives?
I'm not sure.
Has Sheila lived
But-
there with you before?
Yes,
Okay. Before you were arrested, was Sheila living there?
yes.
And how about Nathan?
No, he does not live there
Okay. With whom does he live?
with his guardian.
With his guardian?
Yes,
Okay. And Nathan is your nephew?
yes.
He is the son of whom?
My twin sister.
Your twin sister, and that's not Sheila.
No,
Got it. Where's your twin sister?
Gwinnett.
Okay. And Nathan does not live with your twin sister?
No,
Okay. Does he live in the metro Atlanta area?
The twin sister is in jail. I don't know if she.
Okay, but Nathan's guardian, is that in the metro Atlanta area? You don't know. Okay. When did you last see Nathan?
I don't know.
I mean, when this incident happened? Because he's listed as a victim in the incident.
Whenever this claims were being filed,
Yes.
I was working.
Okay, I'm sorry, I don't mean to probe into the facts of the case, but Nathan was in the metro Atlanta area at the time these claims were filed, it sounds like.
Yes,
Okay, your twin sister is in jail, why?
I have no idea.
Okay. Who else lives at your mother's house?
My sister, one of my sisters.
Sheila?
No,
Oh,
there's another sister.
you have three sisters,
5.
5 sisters. Okay. But Sheila may be living with your mother.
No,
Okay, you just told me a minute ago you weren't sure.
she might. I'm not sure. Like
Okay.
last I talked to my mom, she's not there.
Okay, got it. But a different sister might be there.
Yes,
Okay. You understand that if I sign this bond, it's okay for you to be around Sheila, or Nathan, but it needs to be nonviolent contact.
Yes.
Okay. Let me see if there were any other conditions I want to explore with you. Okay, no, I think I understand it all. Mr. Tiku, anything else on behalf of your client?
Yes, Your Honor, I would ask that the court should accept the bond and the bond conditions. She actually is taking care of the 2-year-old nephew whose mother is in jail. In fact,
Your twin sister's son?
The 2-year-old is my twin sister's daughter.
Daughter,
That
okay.
the state granted me guardian of her.
Okay, you are the guardian, what's her name?
Kinley.
Kindley?
Yes.
Okay, you are the guardian, but right now someone else is taking care of this
My mom.
child. Okay. Were you working at the time?
Yes.
What do you do?
Well, I was driving for Lyft.
Okay. Driving or riding?
Driving.
Driving, okay. And it looks like you've been in custody now for a little over 40 days, 40. So your mother's been taking care of your twin sister's daughter in your absence?
Yes.
Okay. Will you be able to go back to driving for Lyft?
I think so.
Okay.
I don't see why it shouldn't be a problem.
All right. Mr. Tiku, anything else?
no, Judge.
Ms. Smith, anything on behalf of the state? No. All right. I will probably use a standard bond order. I will use the conditions that you all have fleshed out. I'll modify them a little bit. I might not say things about staying away from people of disreputable character. I appreciate the language, but I'll probably use the standard bond form. The important part will be two, the dollar amount, and I'll maintain that dollar amount, and then the no violent contact with Sheila and Nathan, Sheila and Jay. Last question from me. Did you envision this being through a bonding company or through the sheriff's 10% program so that whoever posts the bond can get the money back when the case is resolved?
I would prefer the sheriff 10% program. That's
Okay.
the other option.
That's what we'll do. Ms. Smith, last call. Anything else from the state? Ms. Shalenge, do you have any questions about what we've been discussing?
That's fine.
You understand that someone on your behalf is going to need to post a little over $1,000 for you to get out, but the bulk of what they post will be refunded to them when your case is resolved.
Yes.
And you think your family has those resources?
Yes.
Okay. Then that's what we'll do. You will not get out today. I don't want to give you false expectations. We'll get the bond order out today, but then you'll be able to post it and it could be tomorrow. If you are still in and it's Friday, you should call Mr. Tiku and he'll reach out to my chambers and we'll figure out, wait, how'd you get stuck? Do you think you have holds from any other jurisdictions? Okay, then you ought to be out in the next couple days.
Okay.
Thank you, Mr.
Thank you.
Tiku.
Thank you very much, Judge.
Thank you.
Excuse me, Judge McBurney.
Hold on one second. Yes, sir.
Would that 10% be through pretrial or just through the jail specifically?
What was going to be through the sheriff's program, I'm happy to set it through pretrial services. I don't know that we need it in this
It
situation.
doesn't have to be. I just want to confirm. So it's just
No. Yeah, it's just going to be straight through the sheriff's program. I wasn't going to do pretrial supervision.
Got it. Thank you.
You're welcome. Thanks for checking. So once you fill out that waiver form, did you find it?
Yes, sir.
Great. Once you've got that filled out, if you'll get it to Deputy Gordon, you're good to go.
Thank you.
Okay. Thank you.
All right, what is next?
I'm gonna go convey an offer to Mr. Bailey. Is it Cato Bailey or Bailey?
It's Mr. Cato.
Oh, okay. I'm gonna go speak to Ms. Mahalovic.
Okay, is Ms. Rios back there? Is she able to do one of her remaining? We've got Ford and Francois.
This might be a plea connected to the police.
So who are we talking to? Mr. Francois. We can, okay, all right, I'm running out of time before I have to go to a meeting. I can come back, but I gotta go to a meeting, but I'll keep talking to him. Well, I'm gonna see if I don't get yelled at if I am late.
Thank you.
Yep. That's another Ms. Rios. And I think that's a non-negotiated revocation, Ms. Smith, the Justice Ford.
Yes, that's correct.
Yeah.
And as long as they're not already. But they'll be honest, you. That's right.
They're not sending them to GCIC.
That's who's supposed to be doing that? Thank you, Mr. Tiku.
We send them to the sheriff office.
Oh, sure.
We're supposed to, we have specific contacts that,
I guess someone just needs to follow up to make sure they get uploaded, because we do the same thing. We send it to the sheriff's office, but then you gotta make sure it's.
we're supposed to send on this. To the federal.
I think the other ones were from yeah,
Yeah, I can speak on it. And they were, because I seen way more stuff.
probably Senate process.
Oh, that was it.
Right.
Ms. Rios, we've got a couple of your matters left, Mr. Francois, who I guess is right there, and Ms. Ford. And then we've got Mr. Cato.
Yes,
What's happening with Mr. Cato?
a plea.
Okay, Francois is a plea,
Yes, non-negotiated plea.
non-negotiated plea, and Ford is a non-negotiated revocation.
Yes.
Okay. My thought is we do Mr. Cato because he's, I can do one and I gotta go to this meeting and I can come back and do the remainder. And because Mr. Cato is there, we do that one. I'm sure you think it's fine. But I just think it logistically makes more sense. So Mr. Cato, why don't you come on up, please, to the podium? And would it be better for you to sit or can you can stand? Okay, all right.
Oh, possibly.
Possibly they would need a revocation.
Okay, any reason why? Certainly there wouldn't be a revocation?
Judge, his name, so the reason I was asking about his name, I think he might have been, I'm just trying to confirm how much time he's actually done since this arrest, because there's a possibility he's been in the system a different way. So I'm not sure if he's done the full 30 days the state is offering.
Okay, we'll figure it out. All right, let me do one other thing here. Okay, let's get on the record. This is 25 SC 006-461, State versus Bailey Cato. Mr. Cato is here in court with Ms. Wood, his lawyer. Ms. Smith is handling this for the state. And Mr. Cato, my understanding is that you're interested in entering a plea in your case. Is that correct?
Yes, sir.
For us to do that, Ms. Smith needs to put you under oath, after which she will ask you a bunch of questions about your rights, about you and your case. You need to answer those truthfully. You also need to let me know if there's anything you've got a question about. If something's confusing you or you're curious about something, we need to stop so that Ms. Wood or I can answer your question. Will you let us know?
Yes, sir.
All right. When you're ready, Ms. Smith.
Thank you. Mr. Cato, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Bailey Pierre Cato.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Yes, ma'am.
Yes, you said?
Prescription.
Okay. Tell me what you take medicine for.
I have peripheral neuropathy and vein disease in my left leg.
Okay. How often do you take the medication?
Every day.
Every day. And when you take that medication, does it make you woozy or drowsy?
No.
It helps with your condition, but you stay alert.
Right.
Okay.
Yes, sir.
How old are you and how far have you gone in school?
56 and some college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So moved.
Mr. Cato, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
So I'm not sure the probation matter may be related to this, but we can address that in a bit.
Other than that, nothing?
Nothing.
Gotcha. Is this going to be negotiated?
Yes.
Okay. Mr. Cato, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 30 days with the balance probated?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing,
Yes,
even
ma'am.
on a federal case?
Yes, ma'am.
Are you currently on probation?
Yes, ma'am.
I know we talked about it previously, but I'll just ask you, do you understand that if you're currently on probation, that your probation may be revoked based on you entering this guilty plea today?
Yes, ma'am.
And are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Cato, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 006461, how do you plead to count 1, possession of firearm by a convicted felon, and count 2, driving window tint violation?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal from this guilty plea? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that has to be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Thank you, Mr. Cato. Your Honor, if this case were to proceed to trial, the state would show that on July 23rd, 2024, officers were patrolling an area known for drug activity. This is at 833 Humphrey Street. That's in Atlanta, Georgia, and also in Fulton County. At this time, officers observed a vehicle that was parked illegally on the wrong side of the road. The vehicle also had illegal window tint. So at that time, the officers went to the car and they discovered that the defendant, Mr. Cato Bailey, or Bailey Cato, was in the driver's seat. A K-9 was called to the scene and conducted a free air scan of the vehicle while the officer was completing their traffic citations for the violations for the window tint. The K-9 alerted to drugs in the vehicle. At this time, the officers did search the car where they found a Smith & Wesson handgun that was in the center console. The officers then ran a GCIC check where they found out that the defendant was a convicted felon and he was charged with the crime, with the charges we have in front of us today. Regarding the negotiated plea between the state and the defense, we've agreed to a sentence of 5 years to serve 30 days. For count 1, the sentence is 5 years, serve 30 days, found probated. And for count 2, 12 months probation to run concurrent with each other. And that'd be all from the state, Your Honor.
Thank you for that. Mr. York, I have the repeat offender notice, so I am aware that there are 1, 2, 3, 4, 5 felony convictions. At least that's what the DA's office found. I'm curious to know total number of cycles, most recent cycle, and if you've got more felonies than that, I guess we should talk.
I'm showing 6 felonies. I may have one that they're not showing, but in total cycles, I have 26 out of Georgia, 2 from Alabama. The most recent out of Alabama was in 2002.
And what's the most recent in Georgia?
Most recent in Georgia was a 2025 September. It was APD, driving my license suspended or revoked. That was bound over, so it's not showing disposition, but that's the most recent out of Georgia.
Got it. Okay, thank you.
Yes, sir.
Ms. Simpson, it sounds like from Mr. Cato himself that he's on probation. There's a 22 SC case. Is that the one for which he's on probation? How much time remains on that? 1 month. Okay, well, that's convenient. Given the recommendation here, 184,744. All right, thank you for that. Ms. Wood.
Thank you, Judge. So my hesitation with saying whether we were going to do the revocation today is because my client, Mr. Cato, thinks that he's already done the 30 days as part of this recommendation. I did not bring my laptop today, so I had, right.
2 days.
I wasn't able to find that. I wasn't sure if maybe he was entered in under the name switch or what. But that does change things up because since he hasn't done the 30 days, then he has to go back into custody.
Right.
He's 56 years old. He does have some college education. He has 2 children who he takes care of, ages 12 and 14. He is a tow truck driver. He also does pressure washing on the side. So, Your Honor, he's here. He has the active warrant. He wants to move forward and accept responsibility. So, I think now it just changes up since he hasn't done the full 30 days. I need to explain to him what that means, and if the court would be amenable to a turn-in date.
I am. Mr. Cato, you actually came in here and the first thinking was you were going into custody because there's a probation warrant for you, but it's not official yet. It's been signed, but it's not in the system. And so deputies could not take you into custody. That would have made it kind of easy if they did because you were going in anyway. Why not work all this out? But that warrant hasn't been activated. It's out there and it was triggered by this case. You only have 1 month left in probation. My thought is this is a fairly reasonable resolution, although I do want to hear from you why you know better than to have a gun in your car. But I'm okay if you turn yourself in. You'll turn yourself in here. People don't just report to the jail. So we'll talk in a little bit about when you'll be coming back here to turn yourself in to knock all this out. But before we get there, I need to say some things to you. Before I say some things to you, you have a right to add anything you want if there's anything, but you don't have to say anything at all.
Yes, sir.
You want to add anything?
You don't have to say anything at all.
No? Okay. Don't hang out parked on the wrong side of the street with too much tint and a gun in your car on Humphrey Street. You're old enough now to, I'm guessing you're like, yep, I know the dog's going to sniff, you're going to smell something, and they're going to find something in your car. And if you are still active in your kids' lives, you got to come up with a different hustle. Keep towing cars or pressure washing or something. Mr. Cato, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Knowing meaning you've understood what we've been talking about. Voluntary meaning no one's forcing you to enter this plea. You agree with that?
Yes, sir.
Ms. Wood, can someone in my office sign the indictment? It's actually an accusation. Accusation?
Yes, Judge.
Okay. Ms. Smith? And Mr. Cato, can we sign for you?
Sir.
I'm curious about the most recent arrest that Mr. York from Pretrial Services mentioned. That would have been just this past September where you got pulled over for suspended license or whatever. How are you a tow truck driver with no license?
My license was suspended. My birthday had came and I forgot to renew them.
Okay.
That's all it was.
So it's good. You got a good license right now.
Yeah.
All right. I trust you because towing is going to get ugly for you if the tow truck driver gets pulled over.
Got my birthday. It was a 3 weeks after my birthday.
Bad luck.
Yeah.
When's your birthday?
On the 22nd of April.
22nd of April.
Yes, sir.
And this arrest was in September.
Yeah, that's the same one, I believe. I'm sure.
Okay. That's a long time after your birthday.
Yes, sir.
All
I
right.
just forgot to go
Okay.
get them.
But your license now is
Yes,
valid.
sir.
All right. So if I need you to come tow my car, I don't have to run the risk that not only are they towing my car, they're towing your truck. So it's
No,
like
sir.
a caravan.
No, sir.
Okay. All right. Tell me what works for you. I'll let Ms. Wood vouch. Like, yeah, it's a good picture, everything?
Yep.
All right. How much you weigh? I'm kidding.
32. He's good.
Tell me, Mr. Cato, what makes the most sense for you turning yourself in, coming back here? Is next week too soon? Can you get your things in order? It's not like you're going away for 6 years.
I have custody of a son. I've had since he was born.
The 12-year-old?
He's 14.
14-year-old.
Yes, sir. My daughter, she could go with my son. He's in my care, my custody.
Okay. So you got to line up a situation.
Yeah.
Where's he going to school?
At Kip in the West End.
Good for him. We want to keep that going. How much time do you need to line up someone who's going to be making sure he's dressed and going to school for the time you'll be out of commission?
My understanding, 30 days is 2 days, 2 weeks. Is it?
So you should prepare to be there at a maximum of 28 days. There's no guarantee that the sheriff gives you 2 for 1.
Okay.
I don't control that. So it could be, that's 4 weeks. It could be 4 weeks. It could be less than that, especially if you are just being helpful and a trustee and all that jazz. And you're an older guy, you're probably gonna not want to go with the flow of the 20-year-olds who are making trouble up on 6. That's up to you. So my question is, How much time do you need? Because I'm gonna give you a date to be here, and I'm actually gonna give you 2 sentences today. The one you get if you are here on time, and the one you don't want to get because you weren't on time.
Yes, sir.
So when is it reasonable to?
3 weeks.
2 weeks?
Yeah, 2-3 weeks.
Do you have a date in 2 weeks, Judge?
Yes. How about we start a trial on the 16th? That's 2 Mondays from now. You should show up at 9 a.m. on the 16th. Because we'll be in business. We'll be figuring out who's going to trial. It won't be you. If you are here at 9 a.m., you're not late. You're here at 9 a.m. Are you here? I don't want to set a date where, are you back by the 16th?
Yes.
Okay. 9 a.m. on the 16th, then your sentence is 5 years to serve 1 month with a balance probated. You get credit for your 2 big days. And sentence on count 2 is 1 month to serve. That runs concurrently. And I'm going to revoke your probation, the balance of your probation in that 22 SC case. So they'll just close that one out. You'll have probation going forward on this one, but that other case is closed out, and that'll run concurrently. So it's the 30 days with the 2 days credit. If you are not here on the 16th at 9 a.m. or Ms. Wood, if Ms. Wood is here and she's saying, look, he's coming, here's a picture, the car broke down or whatever. But if you're not here and there's no explanation for you not being here, then it's 6 months. So it'll be 5 years to serve 6 months. So you will have multiplied by 6 the sentence. Okay, I trust you. I just want you to understand the consequences.
Yes, sir.
Is that it goes to 6 months. That's complicated for your son. It's complicated for your towing business. Don't miss it.
Sure.
And blow up her phone if you're running late so that Ms. Wood can say, hey, trust me, we can call you, that kind of stuff. Special condition of your probation, number 1, you forfeit the firearm that was seized. Don't try to get it back. Any other special conditions you wanted?
No.
Okay, that's it. You forfeit the firearm. No guns in your household. Can't do it. None in your car. Anything else, Ms. Wood?
No, Judge, thank you so much.
Who did you bring with you today?
My friend.
Okay. Hi, friend. Can you make sure he's here on the 16th? Okay, good. You make sure his son's in good hands? It's a good friend that you got. Anything else?
No, sir.
That's what we're gonna do. All right, Mr. Cato, take care of that leg.
Thank you.
Oh, and when you come on Monday, the 16th, dress simply, don't bring lots of belongings. There's no way they're gonna let you bring that walking stick.
No, I may have to, I don't know. I can't take my chair either.
No, and they will do what they can to help with your condition. Can he bring medication or how does that work? Nope. But when you get, I mean, you've been in jail before, they're gonna ask you all the things. You need to just be, hey, neuropathy, I take. So if you don't remember your specific medication, write it down. So you can say, this is what I take, 30 milligrams of XYZ, and they will find, if they don't have that exactly, a generic that's the equivalent so that you can stay on the medication you need.
Yes, sir.
All right?
Yes, sir.
I will see you on the 16th at 9 a.m.
Thank you.
Thank you, Judge.
Thank you. All right, I got to scoot. I will be back, Ms. Rios, noon. Thank you.
Thanks, Olivia.
Ms. Smith, sorry. Ms. Rios, what would you like to do first?
Let's do the plea first.
Mr. Francois,
Yes.
let's do that. And we have Ms. Mann. Ms. Mann, I didn't see you at the Icon event.
I'm so sorry. I missed it, Judge. And I'm sure you did a fantastic job.
You know what? With David Banner there, I just was kind of quiet and in the background. That guy is a pretty forceful presence.
Oh, wow. Wow. He is, but you are as well.
Hey,
I
thanks.
hope you're coming back so I can catch you the next time.
Well, that's really up to County Arts and Culture, whether they invite me back. I don't know that they'll be inviting Mr. Banner back, but we'll see.
Okay.
All right. Good afternoon, Mr. Francois.
Good afternoon, Judge.
Sorry to keep you waiting. We didn't get through as much this morning as I had hoped, and then I had a meeting I was not able to move. My understanding is that you're prepared to enter a plea in your case right now. Is that correct?
Yes, sir.
Okay. Well, let's get on the record. Your case is, well, let's make sure. Ms. Rivers, good afternoon. You good to go?
Yes, I'm ready. I'm good to go.
Thank you. It's 25 SC 003949. Mr. Francois is here in court with Ms. Rios, his lawyer. We have Ms. Smith, the prosecutor. And in a moment, Ms. Smith is going to put you under oath and ask you questions about your case and your rights. You need to answer those questions completely and truthfully. I also need you, Mr. Francois, to let Ms. Rios or me know if you've got any questions or concerns. Will you do that?
Yes, sir.
Okay. Ms. Smith.
Yes, Your Honor, thank you. Mr. Francois, you raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Theo Clarence Francois.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone to school?
I'm 34. I've completed high school and some college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
Yes, ma'am.
And are you satisfied with her services?
Yeah.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Francois, do you remember being arrested on these charges?
I wasn't never arrested on them. I got issued a warrant though, and appeared for the warrant. Yes.
At some point, you were in custody in connection with these charges?
Yes. Yes.
Okay.
Yeah.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No.
Mr. Francois, do you understand that this is a non-negotiated plea, or also called a blind plea, and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
We only have one charge here, but the max on that charge. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
And are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or your ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Francois, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 25 SC 003949, how do you plead to count 1, theft by shoplifting?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal to this guilty plea, but if you believe that there's an error in your guilty plea, you can apply to the appropriate appellate court for a discretionary appeal?
Yes.
And do you understand that that process has to be completed within 30 days from today?
Yes.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right, thank you, Mr. Francois. Your Honor, if this case were to proceed to trial, the state would show that on October 6, 2022, officers responded to a target location at 375 18th Street, Atlanta, Georgia, also in Fulton County, on a shoplifter call. When they arrived, they were met by the security.
Ms. Rivers, can you hear us now?
Yes, I can.
Great. Tell us where you dropped off. The podium machine went to the next Zoom session. So I know we got cut off from you.
Okay, Your Honor, if this case were to proceed to trial, the state would show that on October 6, 2022, officers responded to a target location at 375 18th Street, Atlanta, Georgia, also in Fulton County, on a shoplifting call. When they arrived, they were met by the security, and that's where it dropped off.
Okay, you know where you were in your text? All right, we got to cover that again, sorry.
When the officers arrived, they were met by security lead Donna Hayes, who stated that on this particular day, the defendant came into the store with Target bags tucked in their waist. The defendant then went to the gaming equipment section where he used a device to open the equipment from shelves and take those gaming equipments and put them in the Target bags. At that point, the defendant then walked out of the store past all of the points of sale, got into a white Kia Stinger, and left the location. He was not there when the officers arrived at the scene. However, the officers were able to identify the defendant and later arrested him for the charges we have in front of us. And those are the facts of the case. Regarding the recommendation from the state for count one, the state is recommending 5 years for the defendant to serve 3 months and also to get credit for the time that he served so far. Regarding the special conditions of probation, we're asking for the defendant to complete an anti-theft course, for the defendant to pay restitution, which is $2,589.52, and for the defendant to stay away from all target locations. And that is all from the state, Your Honor.
All right, quick question about dates. The indictment, I think it's actually an accusation, lists the date as being in September of 2022. This is all a long time ago. And you were saying something about October. I'm wondering if October is when he got arrested. But and none of this is hugely material. I just want to make sure Mr. Francois is not pleading to a different shoplifting scenario if there had been multiples of them.
That's correct, Your Honor. Here I have that on September 23rd, 2022 is when the officers showed when the security lead showed the officers the clear video image of the defendant. So I'm guessing that's the day it happened.
Got it. And then they caught up with him in October.
Yes.
Okay. And that's, I think Mr. Francois was saying the same. I didn't get arrested the day this situation happened. Okay. Thank you. Ms. Mann, I have seen the repeat offender notice from the district attorney's office, which lists 5 felonies for Mr. Francois. I'm interested in knowing total number of cycles and if you've got more felony convictions than that.
Your Honor, I do not. That is correct. And there are 28 cycles.
All right. And is Mr. Francois on probation right now? Is that something you know, Ms. Mann, or should I get that from Ms. Simpson?
Not according to the GCIC.
Okay.
He is not. Maybe they have something different, but according to GCIC, he is not.
Okay. Ms. Simpson, tell me what you've got. There were a couple convictions out of Cobb from just less than 2 years ago. So I'm thinking those might still be open.
He was in front of corrections custody and he didn't get out until November of last year. And so that's when his probation started.
And how much remains?
He
It's ballpark. I mean, is it years or months?
It's years. They both expire in November of 2033.
Okay. All right. This predates all that, so this is not a revocation issue. This conduct was from in 2022, but that's helpful to know. Okay. Ms. Rios.
Yes, Your Honor.
What do you want to share?
Mr. Francois is 34 years old. He has 1 5-year-old child. Before he got into custody, he was working as a manager at Insomnia Cookies. He did do 2 years at Jacksonville University. He did, after this case happened in October, or it happened in September, but he was arrested in October, he did do drug court. And then, or not drug, was it drug court or drug program?
It was a rehab program.
Drug rehabilitation program, because these instances of theft are related to him having a drug problem. He has been in continuous custody since he was arrested in June 2024. So he went from here to Cobb And then from Cobb, he was transferred from Gwinnett. So he has not set foot on the ground since then. So
He set foot on lots of ground. It just was custodial ground.
yes, not
Got
outside
it.
ground.
Okay.
And so I'm asking, since I'm not sure how that credit works, since here he spent a month and then they transferred him. So just so he's not having any issues of them not counting credit, I'm just asking for straight probation, a 3-year probation sentence, and for it to be able to be terminated after 1 year if not having anything, so he's not on multiple probations for a long
Okay.
time.
Mr. Francois, bunch of questions for you. And then if there's anything you want to add, I'm happy to hear from you. Oh, one for you, Ms. Rios. Are you contesting the restitution, or you've seen in discovery Target was able to say, look, it was 12 games and 6 controllers?
We would like be provided proof of restitution before we agree to the restitution.
Okay. All right. Let's start with the rehab. Where did you do rehab?
It was a program called A Better Way.
Did you get all the way through it?
Yeah, I completed it.
You did?
Yeah, I
Okay.
completed it. I graded out at 10 months. I did 10 months of it.
Okay. And what was the substance you were struggling with the most?
Opiates and fentanyl.
Okay. Well, okay. And when did you do Better Way? Back in 2022, 23?
Yeah, I started it in December of 22.
Okay.
And I finished it in October of 23.
Okay. Good long program. I see that you've got these 2 convictions out of Cobb for theft related things. And those convictions are from December of 24.
Yes.
Did you have a relapse, or those are cases that involve older conduct like this?
They were, all the cases I had happened around the same time.
All before you got
22. Yeah, they
Okay.
were all 22 cases.
all before you got help at Better Way?
Yeah, before I went to the rehab.
Okay.
Yes,
Good to know. Your 5-year-old is a boy or a girl?
Girl,
Name?
Lennox.
All right. And does Lennox stay with her mom?
Yeah, she lives with her mom and her grandma.
Okay. You've been in custody continuously from June of 24?
I've been in custody continuously from November of 23.
November of 23.
Yeah.
And what was it that got you into custody in November of 23?
I was pulled over and I found out I had these warrants.
Okay, for all these different
For
cases.
these I had shoplifting in like four different counties, 4 or 5 different counties.
Okay. Yeah, you got a Fayette County conviction. Oh, that's old. That's from 2015. But you've got the 2 Cobb cases. Do you have open charges now that you have to deal with?
Yeah, I'm in Gwinnett now for shoplifting. And
We borrowed you from Gwinnett.
yeah, you came and got me from Gwinnett.
Okay.
And the Gwinnett's case is from like July of 2022, and I have one more in DeKalb.
Okay. So since November of 23, so you've been in custody for 2 years and 3 months, basically.
Yes, sir.
Going between, were you ever down in the Department of Corrections?
Yeah, I've been to prison twice in that time span.
Connected to the Cobb cases?
Yes, to the Cobb case.
Okay. And then when you were done with your GDC sentence, you had to come back either because you had Gwinnett business or Fulton business?
Yes, sir.
Okay.
The first time I came, when I got out, the first time of prison, I came here and I bonded out and I went to Cobb, and then Cobb gave me 2 years.
When you say you bonded out, as in you were out on the open streets, or when you posted bond, then you were transported to Cobb?
Transported, yeah. When
Okay.
I posted bond and I transported immediately to Cobb.
Okay.
Cobb picked me up from here.
So I know I've asked you this a bunch of times. I want to make sure I understand it correctly because it will affect the way I describe your sentence. You've been in a jail bed at night, every night since November of 23.
Yeah, November 18th, 2023. I've
Whether
been in
it's
jail bed
a state bed or a county bed.
yeah,
Okay.
it's been a jail bed. I haven't been home. Not one
Okay.
time.
And all that relates to things you were doing when you were hooked on opiates and fentanyl.
Yes, sir.
Well, it's hard to know how you do. You haven't been out since then.
Yeah.
So you'll find out how the addiction is going when you get out. So you're going back to Gwinnett after this to resolve a case? There's an open case?
Yes, to resolve it.
Shoplifting?
Same charge, yes, sir. One
Okay.
count.
Got it. All right. Henry County, unresolved,
As far as what I can tell, it was unresolved.
just a hold from Henry.
I don't know if there's a hole, but he does have us in charge.
Okay. Does that surprise you to hear you've got a case in Henry County?
No.
Okay.
I'm on bond there too.
Okay.
When I got out from prison in November of last year for my 2-year sentence, and I went to Henry County.
Got it.
And I made bond in Henry County, and I went to Gwinnett from there.
Sure.
Gwinnett picked me up from Henry.
How are you posting all these bonds? Where's the money coming from?
My family, my dad.
Okay. It's good because you have family support.
Yes, my family. They're the ones sent me to the rehab.
Okay. Well, good. How did you get through the locks? Like at Target, those things are all behind. Is it pretty simple? What do you do to do that?
It was like just a little lock mechanism. You just slide it and it'll open. It was like a plastic case that a game will sit in and you can slide it open.
Okay. You didn't need to bring in some sophisticated laser drill or it was just sort of slide and pop. Okay. Do you have questions about anything we've discussed?
I don't have really questions, but I do just want to make a remark to you, just
sure,
and let you know, like, I did kind of have, probably I don't want to say I didn't have much time off of, I was 13 months clean when I got arrested. Finally, I got pulled over and I had these warrants, and my cycle started in November of 23.
Yeah.
And I just know that that's something I won't ever do. These things happen. I was at a bad space in my life, and I'm just ready to move forward with it.
I bet you are. It's a shame that you put in all that investment into your health and sobriety and had beaten it. And then all this came. It would have been better if prison were on the back end, the front end of all that rather than the back end, because you haven't been able to enjoy the freedom that sobriety gives you. And you've been away from Lennox too. So
yes,
I hear you. I appreciate you sharing that. I'm hopeful for you that maybe there's light at the end of the tunnel. I hope that Gwinnett and Henry will look at the time you've served and say it's all connected. You may have hit stores in a bunch of different counties, but it's all a product of the addiction. It's all kind of contemporaneous. It was in 2022 when you were doing this, but that's up to the judges there and your lawyers there. Well, Mr. Francois, I find there's a factual basis for your plea and that your plea is knowing and voluntary, meaning you've understood what we've been talking about and no one's forcing you to enter this plea. Do you agree with that?
Yes, sir, I do.
Ms. Rios, can someone in my office sign the accusation on your behalf?
Yes, sir.
Ms. Smith?
Yes, Judge.
And Mr. Francois, can we electronically sign your name to the accusation indicating your plea to theft by shoplifting?
Yes, sir.
Okay. Mr. Francois, I am going to sentence you to 2 years to serve on the only count. You are statutorily entitled to credit for all the time you've been in since, I think you said November 18th, 2023, and you will get credit for that time. It may be that Ms. Rios has to do a little digging to get what some of those figures are, but it's documentable. You have been in prison and in jail, so those are all known dates, and you're entitled to credit for all that. I'm not going to set any probation because you've got probation aplenty out of those Cobb County cases. I will say this though, Ms. Smith, if you end up gathering the information you need and want to press forward with restitution, then what you should do is file a motion for a restitution hearing, and I will consider amending the sentence to add some probation on the back end. And the only condition of probation would be to pay the restitution. And as soon as it's paid, Mr. Francois would be off that probation. I just can't add a condition to the Cobb cases for this one. So I'm not interested in depriving Target of that restitution, but I'll let you manage that. And if that comes to fruition, then we'll just regroup and have a hearing on that.
To Cobb,
Okay?
and I went from Cobb to prison.
Okay.
And then I went from prison to Henry, and then from Henry, and I'm in Gwinnett now.
And Ms. Rios, I don't mean to create a lot of work for you, but those dates should be obtainable. And it really only needs to add up to 2. And he's done far more than 2. And it sounds like the biggest chunk, how long were you in the Department of Corrections?
Total time, like I said, I did a 6-month prison sentence first, and then the second time I did maybe 10 months in prison because I got out. I did a couple months, but they gave me time served in Cobb for November of 2023.
Okay, well, it's out there, it's obtainable, but that will close this case out. You think Gwinnett is your next? I guess you'll go back to Gwinnett. We borrowed you from Gwinnett. Okay, all right. Good luck with everything, Mr. Francois.
Thank you.
Bye. I do want to let you know if there's camera one out, yeah.
Okay. Oh, yeah, it's because everything rolled to the other event.
I guess just showing really. Okay, so you see. This is the.
Give me 1 second. There's 4. Okay, let's get on the record. This is 24 SC 002-846. We have Ms. Ford here with Ms. Rios, and Ms. Smith is handling things for the state. And we are together for a second time on Ms. Ford's probation. In November of last year, Judge Mao revoked your probation after you were discharged from the day reporting center. I think then sent you back to the day reporting center. I'm not sure. We'll work through that. I don't want to misrepresent what happened, other than that you've already had one revocation in your case. But we're together because I signed a warrant in January of this year that alleges that you continue to struggle with drug use, bunch of positives for cocaine, left some sessions early, and you weren't able to stay awake in some of your day reporting center classes. So these are what I'd call technical violations. The good news is you're not getting into new trouble with Mr. Murphy or anything else like that. But you're certainly wrestling with some challenges, and we need to figure out how to get you support for all that. Ms. Rios, first, let me know, is it really 2 times in the day reporting center and 2 times being terminated from it? Yes, okay, Ms. Simpson said yes. All right. Okay, tell me if Ms. Ford is admitting to these allegations.
She is stipulating to the allegations.
Okay, and what are you recommending we do to connect Ms. Ford with more resources or something different?
Your Honor, and I believe a lot of the causes for like the drowsiness and sleepiness, she's on a lot of medication. She has been on disability for her medication since she was in middle school. She's been in a month. She wants me to ask to revoke just the month that she's been in. I have talked with probation. I know their solution is for her to go to the DRC program, or is it not DRC? What's it? ITF. I'm sorry, I don't know about the ITF program. And so I know the goal is for her to get into the program, and they have a waiting list of 3 months. So that's why I believe the state's asking for, and probation asking for 5 months. But her position is she wants to be able to be out while she waits for this program.
Okay. So you're not opposing the notion of ITF, it's just be able to wait out of custody for enrollment in ITF?
That's my understanding, right? Yes.
Okay. Ms. Ford, tell me what you take medication for.
Anxiety, Lexapro for mood stabilizer, and Viscera, Lexapro, hydroxyzine.
But what, I don't need the name so much because those are hard to spell, but you take the medication to help with anxiety,
Yes.
to help with mood stabilization.
And
Any other diagnoses?
just the bipolar and the anxiety.
Okay. And are you getting those medications in custody?
Yes.
Were you getting them when you were out?
Yes.
How were you getting your medicine?
I will go to River Edge in Macon.
Okay, in Macon?
Yes, I'm from, that's where the probation was back in.
You were being supervised out of Bibb County?
Yes.
Got it, okay. So you weren't having to drive far to get to River's Edge, it just, you were in Macon?
Yes, sir.
Okay. Okay, and it sounds like you got a couple chances to make the day reporting center work. One time it didn't work and Judge Mao said, we're gonna try it again, I guess. And then this is the second time. All right, I think I understand all that. Your original case was pretty serious charges. You got first offender. Ms. Smith, are you seeking to have first offender revoked, or you're okay leaving first offender in place but get Ms. Ford more treatment?
The latter, get Ms. Ford treatment.
Okay. Anything you want to add to what we've heard?
No, just to reiterate that the state's position is to revoke 5 months and for the defendant to complete with the ITF program in this case.
Okay. Now, it's not that Ms. Ford would necessarily have to serve the 5 months. It would be that allows enough of a wait time for there to be an opening in ITF.
That's correct.
Okay. Ms. Simpson, my recollection is that one is not able to get on the waiting list for ITF outside of custody. Is that correct? Okay. In your most recent word from your team is that the wait is about 90-ish days to get into the integrated treatment facility?
ITF program is 3-month waiting period.
Right. It's always longer. They have fewer beds.
Yes. I did advise Ms. Rios that we could still do the credit, because she's only been, my recollection is correct, a month. Which will allow her to still get the credit, but still give the leeway time for her for the wait list.
Okay, got it. Okay. So Ms. Ford, the dilemma I face, I understand your request. If you're stuck waiting, why not let you wait in the comfort of home? And then you're willing to turn yourself in, but they don't put you in the line to get this helpful treatment unless you are in custody. And I get the sense that you do need it. I'm hearing you say you want it. That puts me in a little bit of a bind. I'm glad Judge Mao said, let's try the day reporting center a second time just to see. But you're working through some complicated challenges. It sounds like, and I'm not putting conduct on you, but it sounds like you may also do some self-medicating, that you take the medication the doctor gives you, but you feel less anxious and more stable if you also use some other things as well. And we got to help you move away from that. Tell me what your situation is in Macon. Who are you staying with? Family, friends?
I was staying with my mom. Me and my boyfriend, we just moved into our apartment on the 27th.
Okay. Does your boyfriend work?
Disability.
He gets disability. Okay. All right. Had both of you been staying with your mom, or you were staying with your mom and he was staying somewhere else?
I was staying with my mom. He was staying somewhere else.
Okay. Got it. How long have you two been talking?
Like December.
Okay. How'd you meet?
Facebook.
Okay. Do you have any questions about anything else?
I was accepted in Women on the Rise. Due to me leaving last time, there was a rehab that they were trying to send me to, but they want the place they wanted me on a certain type of medication, but I wasn't having those side effects, I guess, like the hearing voices and stuff. I wasn't having that due to me with the drugs, but so that they wouldn't take me then. But
Ms. Ford, you said something I want to make sure I understand. You did Women on the Rise once before,
no,
but you walked away from?
no, they still have me on their list. I'm still with Women on the Rise. It's just the program she was trying to put me in, they didn't have any space available. So she told me to keep checking in. She would check in with them and they wouldn't have any beds available. But
Well, let's do this. I do find that you violated your probation, and I am going to get you in line for the integrated treatment facility. If between now and then, Women on the Rise, this opportunity you were describing in this facility, this program, if that opens up, you should let Ms. Rios know, and she can always petition for us to have another hearing. And if she can get someone from that program to come on in here and to say, well, here's what we offer up, and I'm comfortable that it's the kind of thing that you'd take seriously, you wouldn't walk away from, et cetera, I'm open to considering that. The reason why I am more inclined to go with the ITF is that that's one that you can't walk away from. And so you'll get the treatment that you need. I know you would like to be back in Macon, you would like to be with your boyfriend, but we need you to be as stable as possible while that's happening. And right now we've got the day reporting center, not once, but twice not working out for you. So I'm just trying to get you that solid foundation that I know you want, okay? Ms. Rios, you have anything else?
One note, because I know technically after she gets credit, it'll be 4 months. If the program, since it's typically a 3-month waiting, if it's a little early, will someone let us know so we can get her out, or should be automatically transferred no matter what?
Yeah,
Okay.
they'll shrink the revocation down to the wait to get in. She wouldn't miss out on a bed. If in 42 days a bed opens up, that is her bed, and she's off and running.
The transport date she can
Yeah, and she gets credit on her probation time the whole time she's at ITF as well. This is not like it gets told. So most importantly, she's making progress on sobriety, but she's also working on the term of probation that she's got. Ms. Ford, you still have your first offender status, and I'm willing to keep that in place because we're going to try this more rigorous programming. We'll see how it goes. And like I said, if something comes up, Ms. Rios will let me know. All right? Thank you. Ms. Rios and Ms. Smith and Ms. Simpson, thank you for staying a little late because I had that meeting. Appreciate it. I think we've covered everything.
See you tomorrow.
Tomorrow, before you guys bust out of here, what do we have? Jail Zoom. Okay.
That's gonna be fun.
It always is. Hold on one second. Right, I think the motion we had in the morning, which didn't involve any of you, we moved, it had Mr. Apt on it, and we're moving that. So I will see you around 1. Okay? All right.
Your Honor, I got a notice to be here today for a motion.
Okay.
Elijah Thomas, SB 440.
Okay, before the DAs bust out of here, do you have the case number?
I do, Your Honor, it's. I should have been ready. It is 25 SC 006136. Didn't file any substitute motion.
Then that's probably why you don't need to, so it is an SB 440. It says he has a warrant. Is he in custody? Okay. Okay. The motion's date is, only if there were substantive motions filed. So you were extra thorough in the future, if we've got a case together. Yeah, check with Ms. Nelson, my litigation manager, and she would have given you the all clear saying, hey, I appreciate you reaching out, but because there weren't motions filed, you don't need to be here. All right, but I appreciate the thoroughness.
It would depend on the charge. I mean, if it's a gang case, whether it's a case. Is there any underlying?
It's Ms. Smith. She's right there.
It's Ms. Smith.
So it's not gang.
Nope. Yeah, it's not gang related, although it is a whole bunch of defendants.
It is a whole bunch of defendants.
But it lists Ms. Smith on the discovery certificate. So,
Unless there's a felony murder or a gang charge, it's gonna be hers on that one then.
yeah, there's a kidnapping. They're getting close.
Doesn't hit the criteria.
Kidnapping.
And Jed, what time did you move the motion? I think it was Ms. Williams' motion tomorrow. Just wanna make sure I'm keeping coverage on it.
So it says Fawcett.
And not my problem.
Yeah, but it was a motion to exclude identification evidence. I think it's an old murder. Would that be Fawcett? Does he do?
This is a deputy, so it ain't my problem.
Yeah, but it got moved to a whole nother day. So Mr. Apt, of course, has to be somewhere else. So I think our first thing in terms of your coverage is the Zoom calendar. All right?
Yeah, GA, public defender, GA, public. I understand. All one word, GA, public defender.
That will work? Or that
That
will
will
work?
work,
That
yes.
work, okay. I'll send you an email now so that way you have my email address.
Thank you. I appreciate it, so that we can talk.
Yeah, no problem.
Yeah, I don't remember much about this case, but it's 4 defendants.
It's 4 defendants, my client's Simon Jr.
Huh. Okay.
He's about to turn.
He's in that scope, fourth ball, right? The direct of your
Yeah, but I left something up there.
Chambers, Cotton.
It's something we
Well, good, then I will get out of your hair.
All right.
I appreciate it.
Thanks for coming by.
I just figured better safe than sorry.
I agree with my wife.
Okay. That'll be great.
We're gonna take the seats.
Thanks for your help. I'm going to call him up right now. Yeah.
I'll make you.
And I'll get the Zoom going. So if you all are here for the fees hearing in VBT versus Dunn, come on up and take your places. Ms. Rivers and Ms. Mann, thank you for your time. I'm going to end this Zoom and start the Zoom for the civil. That's the thing that shut down our audio about 20 minutes ago, but I'm going to start that one up. I appreciate you guys' time.
Okay, James.
Thank you so much, Your Honor. Have a good
Bye-bye.